Hello again, and welcome to What's Working. I'm Cam Marston. Thank you so much for joining us on another show this week. Got a guest coming into the studio this week who, if you are an employer, you're going to want to hear this. She is updating us on all the new federal guidelines around employment. One of which leaps out to me is as an independent contractor. In the federal rules around what defines an independent contractor are being evaluated. She sent me a briefing. She's an attorney. Her name is Wendy Bitzer. She sent me in a briefing, what's called an employment alert from her law firm. And I've highlighted a great deal of it, some of which applies to me, some of which does not. We will get into content about non-compete agreements and how the federal government is trying to eliminate all non-compete agreements. I'm not sure whether it will make current ones ineffective or not, but preventing those from going on in the future. There is opposition to this idea of non-compete agreements. If I understand it, largely the opposition is coming out of the U.S. Chamber of Commerce on behalf of private business. They are quite fond of non-compete agreements. And she's going to give us other updates on workplace and employment trends. So again, if you're an employer, this week's show will have a great deal of bearing on the world in which you operate and how you view your contractors, your employees, etc. A lot getting into that. Now, in the past many weeks, I've been promoting our book report or our book review, if you will. We've had to punt on that and push it down the road. If you're not familiar with what I'm talking about, we're going to have the author of the book called The Author versus the Editor Dilemma. His name is Brandon Smith on the show. And this book, The Author versus the Editor Dilemma, has been recommended to me by a couple of different people. And I thought, why don't we get the author on the show and have him talk us through the book and the lessons taught in the book? And that's what we will do. In addition to the author, we will have a business consultant, a executive leadership consultant who uses this book extensively in his leadership coaching, as well as one of this leadership consultant's, let's say, customers, clients, students, about how he uses the book regularly, says it's on his desk all the time, and makes references to it. In other words, we've had a number of remarkable references to this one book, and we will discuss it. So my hope for you is that you pick this book up and take a look at it, The Author versus the Editor Dilemma, and send me any questions you may have about that you could ask the author about the book, and we will bring it up in the show. We are now looking at putting this show out the week of July the 15th. Again, due to various things, I'll be candid. Due to me, I had to run off to a client event in St. Louis the week that we were going to record this show, and it caused all four people to have to try to coordinate calendars. And as I'm certain you're familiar, trying to get four people with four different organizations to coordinate calendars so that we could all be present and together for 1 hour is not easy, which has caused us to have to push the recording back so that it will be broadcast the week of July the 15th. You can find The Author versus the Editor Dilemma online on Amazon. Go ahead and pick one up. Be ready to discuss with us. I'm also happy to say that I've booked a guy named Connor Lokar to be on the show. Connor is an economist, and I've heard him speak several times, most recently in May. He's hard to pin down. He's busy. He has some compelling content, one of which is said in May, if I understood him correctly, we are in a recession right now, if it weren't for government spending. And I talked to another financial guy about that, and he says, Cam, that's always the case. It's always the case if it weren't for government spending. I want to dig more into this. Additionally, Connor and his firm predict a huge economic upheaval around the year 2030. They've been predicting this for a while. Essentially, we're going to all go back to being farmers raising food for ourselves if his predictions come true. We'll talk to him more about that. When we come back from break, Wendy Bitzer and an update on workforce regulations.
This is Seth Cherniak, Vice President of Branch Development for the Jeffrey Matthews Financial Group. If you're an experienced financial advisor wanting the freedom of independence but aren't sure making that jump is right for you, we should talk. Jeffrey Matthews has developed a successful program for advisors who don't want to be 1099 contractors and don't want to pay for their own overhead. We're looking for advisors who want the freedom to run their business the way they see fit, with the support that comes with a W-2 firm. If you're interested in joining one of our branches, or if you want to open your own branch as a full-time employee, let's chat. Our compensation plan is one of the most competitive among all W-2 firms, big or small. Reach out to us today at jeffreymatthews.com, connect with me, Seth Cherniak, on LinkedIn, or click the link in the podcast.
Jeffrey Matthews Financial Group, member FINRA, SIPC. We're back. You're listening to What's Working. I'm Cam Marston in the studio today, and sitting across from me is Wendy Bitzer. She's with the law firm Hand Arendall, Harrison & Sale. She is an expert on workforce law, and there's so much to it. And in our brief conversation prior to turning on the microphone, we talked about enough content that could take us through this show plus 2 or 3 more. But before we get into the weeds on this, Wendy, thank you so much for your time and welcome to What's Working.
Thanks so much, Cam.
I'm glad to see you again. I'm glad to have you. There's a lot going on out there. And as I said before we turned on the microphone, I said, what do you think are the most pressing things that my listener needs to hear about? And you said the non-compete ban should top the list. Go into that for me, if you will. First, let's define what it is.
Sure. So your listeners have probably heard or maybe have non-compete agreements with some of their employees. Perhaps your listeners are even subject to a non-compete agreement. And in essence, a non-compete agreement is an agreement that an employee enters with their employer that says for some period of time after they separate from employment, they will not compete with that employer. So the developments that have happened recently include earlier this year in April of 2024, the Federal Trade Commission voted by a 3-2 margin on party lines, no surprise, to issue a final rule banning non-compete agreements nationwide. And the effective date of that ban is September 4, 2024.
September 4, 2024. Are they retroactive so that current non-competes are suddenly null and void?
The rule prohibits all non-compete agreements with very limited exceptions, and yes, it would apply to those that are in existence as of now, unless there is a pending claim on them. And the limited exceptions would include existing non-competes for senior executives who earn more than $151,000 a year and who are in policy-making positions. Those agreements that are in effect will remain in force. However, new agreements for such senior executives would not be permissible and would be illegal.
Why do they call out the senior executives? What makes them different?
Well, I think the idea certainly is they would be more common. You don't want a senior, and from my perspective, you wouldn't want a senior executive who's had a high policy level making decisions and access to all, your proprietary information going out and competing with you. And so I think that this was actually a compromise. There was a proposed rule that the FTC issued and they received comments. And so I believe that this was a compromise in the final rule to allow them that are in existence to continue, but to disallow them going forward.
When a friend of mine sold his company recently, part of that agreement was a non-compete with him. Does that include someone like him as well, or is that transaction makes it something different?
That is also one of the other very limited exceptions, and that would be when non-compete agreements are part of a bona fide sale of a business entity. So that may fall within the exception. But outside of that senior executive exception and this bona fide sale, all other non-compete agreements would be held illegal.
What is the motivation behind, I guess it's our federal government, of doing this?
Well, the rationale that the Federal Trade Commission has stated is that they're an unfair method of competition, and that they believe the ban will promote competition, increase innovation, protect workers' abilities to change jobs, and foster new business formation. They also say that non-compete agreements keep wages low and suppress new ideas and new business growth. This was a shocking number to me, really. The FTC said they estimate that about 30 million workers, or 1 in 5 Americans, are subject to non-competes.
That is surprising.
Yeah, that was a higher number than I would have anticipated.
That's nearly 10% of the nation's population.
So opponents to the rule, obviously, though, and those who favor the opportunity to have non-compete agreements assert that they're necessary to encourage business investment, and that non-compete agreements are already heavily regulated under state laws with appropriate limitations and safeguards. Now, know that there are some states that do ban non-compete agreements. California has a ban on non-compete agreements.
Really?
Yeah.
That surprises me, considering all the technology developed there, that they would ban that. They would seem to value or favor that in California.
But there are other states like Alabama that we're in that have state laws already that regulate non-compete agreements. And, you know, you have to meet certain criteria. You have to have a protectable interest, and the limitation has to be reasonable in time and geographic limitations. So the opponents to this rule say there are already laws in effect, and we don't need the federal government telling us, you know, to ban all agreements.
So this is the opponents say this is a state issue versus a national issue.
That's certainly one of the arguments, yes.
We've already discussed this at the state level.
Mm-hmm.
Are you familiar with non-competes historically being challenged in the court, and do they typically stand up?
Yes, I am familiar with them, at least in our local area where I practice. You know, I had a case, it's probably been 10 years ago, where we sought to enforce a non-compete agreement against a salesperson who sold ads for a radio company.
Oh, really?
Mm-hmm.
Highly ironic that here we talk on the radio about that. Yeah.
And, you know, we went to federal court and tried to enforce the non-compete agreement, and were successful. And Alabama law was the law at stake and at play there. And, you know, we were able to demonstrate that the non-compete was narrowly tailored, you know, to the specific interests at hand. It was reasonable in time and geographic limitations. The individual was not barred from any sales job, but, you know, the non-compete was drafted in a way such that she couldn't transfer to go work in the same market for a limited amount of time doing the same sorts of sales.
Mm-hmm.
And the federal judge sided with our client and enforced that non-compete.
Do you think most people who are subject to non-competes are aware that they're subject to non-competes, or is the verbiage of that buried in some document that they signed in their orientation process, and they're not aware that they're subject to this until they let go, they dismiss or something like that?
I think employees know that they're signing them. They may not understand the ramifications of them until they're ready to leave. But it obviously has to be conspicuous and, you know, signed with knowledge. And I will say, I think that employees are much more savvy these days.
Mm-hmm.
And I think that when they may be recruited or they're, you know, looking at new opportunities, that's something that they'll keep their eyes out for.
Is it your advice to employers listening that they become very clear and aware of their own non-competes and perhaps need to update them due to this forthcoming law? Or is your advice, sit on your hands for a little bit, let's see what happens?
Well, both, frankly. I do think that we will have an answer to whether the FTC ban will go into effect relatively soon. There is litigation right now in federal court in Texas. As soon as the ban was announced, a tax services firm in Texas filed a federal lawsuit, and the U.S. Chamber of Commerce has since joined it. And they have argued to the court that this rule was outside the scope of the FTC's authority to make. And the federal judge has briefs on the issue and has indicated that he will rule on this by the July 4th holiday.
Is it reasonable to think that if November we see a change in the party that's running our nation, all this could be done away with? This whole litigation process is just suddenly null and void because a Republican has taken the presidential seat?
Yes, I think that is a fair assessment.
All right. So what we may be talking about here is, come November, a moot point, but we won't know that until then. And as we've seen in the past, a lot of these moot points tend to come up in the next administration if it's of a different political party, correct?
That's right.
Yeah. All right. We're going to go to break. I'm sitting in the studio today across from Wendy Bitzer. She's an attorney with Hand Arendall, as they're better known around here. We're talking about changes in employment law. We'll be back after this break.
This is Bill Eastet. I perfected my baking recipe behind my live music stage at my little restaurant in Fairhope, Alabama. We have custom-made smokers and small batch bacon made just for you. So if you're looking for the best bacon in America that has been cured, smoked, and even serenaded by songwriters, you definitely need to try Billy's Small Batch Bacon. www.billiesbacon.com.
We are back. You're listening to What's Working. Wendy Bitzer is in the studio with me today. She's an attorney with Hand Arendall. She knows the weeds of employment law. It's changing rapidly. She told me prior to us beginning this recording that there are hundreds of pages of documents with each of these laws, and it's her responsibility to understand them in order to best consult with her clients. And we're going to get into, we talked about non-competes in the previous segment. We're going to look at overtime exemption, which, according to Wendy, has significant potential to impact your budget, your pocketbooks, lots of things. Wendy, let's begin with an understanding of what the overtime exemption is and then what the changes are.
Okay, Cam, the Federal Labor Standards Act is the federal wage and hour law, and it requires employers to provide minimum wage and overtime pay to each employee unless that employee qualifies for an exemption. I'm sure most of your listeners are familiar with the term exempt employee, and that means the employee meets certain prescribed duties, is paid on a salary as opposed to an hourly basis, and their salary meets a minimum threshold, which is currently $35,568 per year. You have to meet all three of those criteria for an employee to be an exempt employee. And what has happened is that recently is that in April of this year, 2024, the Department of Labor issued a final rule which increases that minimum salary threshold for the overtime exemption. And it is set to take effect July 1. This year, in just a week or two.
Yeah, just around the corner.
And it's expected to impact millions of American workers.
So it was $35,568. And now the federal government is saying, wait a minute, if they make more than that let me understand, to be exempt, they must be paid. That's the current threshold. Right.
As of July 1,
right,
an employee must receive the equivalent of $43,888 per year to remain an exempt employee.
I see.
And then there's another step increase effective January 1, 2025. That minimum threshold, then it's a step up. It's $58,656 per year. So within, a 6-month period of time, you're going to be increasing that minimum threshold by, $23,000, which is significant.
The federal government is making it harder for employers to claim exempt employees.
That's right. And the theory is that, the employees should receive overtime if they're overtime pay, which is time and a half,
right,
if they're not making that threshold.
If they're salaried, how is overtime determined? What is time and a half on a salaried employee? Do they just divide their salary by hours worked?
Well, if they're a salaried employee, I mean, they have to have this minimum threshold to remain a salaried or exempt employee.
Okay.
So you've got situations, and we've been in contact with clients who are making an assessment currently of what currently exempt classified employees do they have that are making less than what these new thresholds are going to be. And are they close? And so maybe they would remain exempt and they just bump their salary a little bit. But if they're not close, they're going to have to transition those employees to non-exempt salary, meaning they're going to be hourly wage workers. And if they work more than 40 hours in a work week, they're going to have to be paid time and a half.
Once they're hourly, does it mean they have to clock in? They have to track their hours?
They have to track their hours, yes. And so that's going to be a significant change in, kind of morale, prestige, and processes for those individuals.
So are employers aware of like you said, budgets? This is going to be expensive.
It is going to be expensive. And, we've had clients who have predetermined budgets and, how do you assess this? And particularly we've seen some challenges, nonprofits, they can't increase the salaries for certain individuals. So they're necessarily going to have to revert those employees to non-exempt status.
What's the motive behind this one?
The motive is I'll say the federal government is that salary threshold that's currently the $35,566 has not increased in years. And so they think that workers need higher wages.
Inflation.
Sure.
Many factors could go into this. Workers need higher wages. The cynic in me says the federal government is after some sort of increased tax ability to tax, increased payroll taxes or anything like that. Does that line up?
It does, in my view. They're not going to say that, though.
Yeah. What does enforcement of this look like? Is there somebody walking around into employers unannounced saying, let me see your payroll? Is it something that can be seen in a tax return? How do people get busted on this? Yes,
the Department of Labor does have enforcement abilities, and they can do audits and investigations, certainly. I will say, the non-compete ban that we spoke about earlier, this new rule is also subject to legal challenge.
Sure.
And there are pending lawsuits right now. One of the lawsuits was filed by the Texas Attorney General, who's seeking a TRO or temporary restraining order to block implementation of the rule. The court has set oral argument on that motion on June 24, which is just 1 week prior to the rule's implementation. It's hoped that the court would issue an opinion prior to July 1. But as of now, the July 1 deadline remains. And so we're not advising clients to make the change until July 1 because, it could be stopped prior to then. But there needs to be consideration of if you have employees who fall under these new thresholds, what are you going to do and how are you going to transition them? Or are you going to increase their pay? Are you going to transition them to hourly wage work? And then at what wage?
Right.
Are you going to base what their salary was based on a 40-hour a week, or did they typically work overtime such that, your calculation would need to assess, well, that's what they really were making for, an approximate 50-hour a week.
Yeah. There are many, many employers in the nation that I would suspect don't keep up with this. And I suspect if the Department of Labor were to walk in and say, hey, you've broken these rules, they would say, what? I had no idea. I'm just trying to make ends meet, some sort of innocence claim or something like that. That won't hold up, will it?
No, it wouldn't.
It wouldn't hold up. Mm-mm. Does the federal government feel a responsibility to communicate these new rules in such a way that Bob's convenience store at the corner can understand what's going on?
I think they would say that they do that, but I'm not sure how well it is communicated.
Yeah.
And I think that is a challenge for your, a typical business, perhaps that, doesn't have a a large payroll or HR department.
Right.
As I mentioned to you earlier, maybe offline, there are new rules and regulations that come out all the time, and it's a lot to keep up with, even for employment lawyers. And the idea that your HR director, who's a professional and trying to keep up, it's a lot to keep up with.
Right. And I'm curious of how many businesses out there. If the vast majority of businesses in this nation are small business, how many of them have an HR director? Right. How many of them even contract with an HR director from time to time? I know it's becoming an increasingly important part of the workplace. And in fact, a Stanford economist I interviewed on the show not too long ago said his next piece of research was the growing influence of HR in the boardroom. But you got to wonder how many people, other than perhaps those listening to shows like this, would ever learn about this type of thing. So it's a bit frightening for my listeners out there, I would say.
Well, I think it should be. And, if they use the benefit of a payroll company, I would think that they may be able, or they probably have provided some information about that, but it's certainly something to keep an eye on.
Yeah. Wendy Bitzer is an attorney with the firm Hand Arendall, Harrison & Sale. She lives here with me in Mobile, Alabama. However, her work takes her, or her expertise is countrywide. We'll come back after this break with a couple of more things that I think you as a business person need to know about. You're listening to What's Working. I'm Cam Marston. Be right back.
This is Seth Cherniak, Vice President of Branch Development for the Jeffrey Matthews Financial Group. If you are an experienced financial advisor wanting the freedom of independence, but aren't sure making that jump is right for you, we should talk. Jeffrey Matthews has developed a successful program for advisors who don't want to be 1099 contractors and don't want to pay for their own overhead. We're looking for advisors who want the freedom to run their business the way they see fit, with the support that comes with a W-2 firm. If you're interested in joining one of our branches, or if you want to open your own branch as a full-time employee, let's chat. Our compensation plan is one of the most competitive among all W-2 firms, big or small. Reach out to us today at jeffreymatthews.com, connect with me, Seth Cherniak, on LinkedIn, or click the link in the podcast.
Jeffrey Matthews Financial Group, member FINRA, SIPC. We are back. You're listening to What's Working. Wendy Bitzer sits across from me. She's an attorney with Hand Arendall. Her expertise is employment law, as well as other things, and she's given us some updates on some of the biggest changes that we need to know about. Wendy, this one catches my attention just because of the title, the Pregnant Workers Fairness Act. Let's jump off there.
Sure. So in December of 2022, Congress passed the Pregnant Workers Fairness Act, and that act went into effect in June 2023. And basically, that act requires employers with 15 or more employees to provide reasonable accommodations to employees or applicants who have limitations that relate to pregnancy, childbirth, or related medical conditions, unless the accommodation would cause the employer undue hardship. The EEOC, which is the Equal Employment Opportunity Commission, issued just recently its final regulations interpreting that act, and those regulations became effective this week on June 18th, 2024. This law is broader than the Americans with Disabilities Act because it allows for employees to be temporarily relieved from performing essential functions of their position if needed. So it is more generous for employees in that sense.
So a Pregnancy Fairness Act, there's, let's say, 9 months of pregnancy. How far after pregnancy does this act influence the behavior of the employer to the employee?
Well, it depends on the circumstances, individual circumstances, of course, but I think that the expectation would be that it would be similar to in terms of perhaps leave, pregnancy leave would be similar to that provided under the FML, which is about a 12-week period. But it goes beyond that too. I mean, if a person were to have postpartum depression, the Pregnant Workers Fairness Act would cover that as well, and the employer would have to engage in the interactive process with the employee to see what that limitation is and to provide an accommodation if necessary.
This is a tricky question, but this is our world today. How does this apply to the fathers?
I don't think that this one does. This is for individuals who have conditions that relate to childbirth and pregnancy. There are other laws that would enable a father to assist or to take leave, for example, once a child has been born for bonding. That would fall under the Family Medical Leave Act, for example. And certainly if the spouse who was having the child was in the hospital and the father needed to take leave to care for his partner, then that would also fall under the Family Medical Leave Act.
So if I claimed I was having sympathy pains for my wife's pregnancy, or I was having morning sympathy sicknesses, I'm being facetious here, but I think in our world it may exist out there. This new Pregnant Workers Fairness Act would not apply to my male morning sickness yet.
Well, it's a new law, Cam, so, there's always room for case law to be developed. We'll just have to wait and see on that one, I think.
You mentioned to me prior to the mics going on trigger words, such that if a pregnant worker in my workforce were to say, "I'm sorry I'm late, I've been having morning sickness," then I, as that manager or supervisor, need to interpret that beyond the simple statement, but into something else. Could you expand on that?
Sure. And this is similar to situations under the Americans with Disabilities Act, where employees, if they need an accommodation, they're supposed to ask for one. But courts have said that employees don't have to use magic words necessarily. And, the question then is, has an employee fairly put an employer on notice that they have a medical condition or some, limitation for which they need an accommodation? And so in the example you just gave, if you had an employee come in and say, "I'm sorry, I'm late, it was morning sickness," and perhaps it's more than once now, and they're having problems, that's enough. I think that a court may at least get by for a while in its analysis of whether the company had reasonable notice that an accommodation may be needed. And the employer's obligation is to engage in what's called the interactive process, meaning communicating with the employee to determine what the limitation is and what the accommodation, what an appropriate, reasonable accommodation may be. And under the Pregnant Workers Fairness Act, the EEOC has again reiterated that the types of accommodations provided must be tailored to the individual's needs, but they've also identified certain accommodations that must be offered in virtually all cases. For example, allowing an employee to carry or keep water near them and drink as needed, so perhaps modifying, internal policies about having, liquids or food nearby, and allowing an employee whose work requires standing to sit on a stool instead, or vice versa, or to allow an employee to take more frequent breaks for the restroom. And so the EEOC has said these are things you're going to have to do.
Right.
Otherwise, if there's more to it, if there needs to be a job reassignment, or if there needs to be a schedule change, for example, instead of coming at 8 o'clock in the morning, they start at 9 o'clock because of morning sickness.
Yeah.
Those sorts of things will depend on the individual circumstances.
Wendy, how do you feel about these changes? You see them, you're in the weeds on this all day. My impression is that you mostly represent employers versus employees.
That's right.
How do you feel about all this?
Well, I think that this particular law kind of fills some gaps. The Americans with Disabilities Act has the same sort of procedures and requirements for employees, but pregnancy in and of itself is not considered a disability. And you also will have other employees who don't necessarily or haven't necessarily met the minimum threshold requirements to qualify for Family Medical Leave Act. So this kind of levels the playing field for those employees who haven't satisfied those requirements. I think overall, it's, it was a bipartisan law. Both Republicans and Democrats supported the law. Now, there have been some challenges to the regulations that the EEOC has just recently implemented. And I can speak to those if you want. But the fact is that, it is the law and it's what employers are required to do. And they're already doing it in a lot of other respects. So this just extends the obligations for the employers. And, from a family perspective, I certainly support it. And, and I think that most employers would do this anyway.
You'd like to think so. I agree.
I do think that they would do this anyway. But now it's a law and they have to.
Are most of the calls that you get, Wendy, from employers that feel like they're being abused, their generosity or their employment is being abused? Is that when your phone rings?
Well, it rings with those types of questions, but for the most part, they want to make sure they're doing the right thing as required under the law. And
so they're playing defense when they call you.
They're trying to be proactive and make sure that what they have proposed to do or think they should do is what is consistent with what their legal obligations are. No one wants to be sued.
Right.
And so it is a preventative measure. And a lot of my day is spent with, random calls. It's not how I'd planned my day to be. But you have calls on a Friday afternoon. It's like, I think we need to terminate this person.
Yeah.
You walk through the scenario and you, see if there might be legal challenges, and there are always risks, but you do the best you can.
Wendy, there's someone out there that's listening that would like to get your attention, certainly. How do they find you?
You can go to our firm's website, which is www.handfirm.com, and we have attorney bios on our website, and mine is there, so they could reach out that way.
It's Wendy Bitzer, folks, Bitzer. Very comprehensive knowledge, as you can tell. And Wendy, thank you so much. I'd love to have you back to talk about what else is going on out there at some point.
Thank you, Cam. It's been my pleasure.
You're listening to What's Working. We'll be back after this break with final comments, some things that I've heard, and things that you can expect in upcoming episodes. Again, you're listening to What's Working. We'll be right back.
I'm Joey Mason. For 4 years, my goal has been to produce the best farm-to-table products I'd ever eaten. I've done just that at our on-site USDA facility in Grand Bay, Alabama, allowing us to ship directly to your door. This is true farm-to-table. Visit us at masonhillsfarm.com to see all that we have to offer.
We're back for segment 5 of What's Working. And it's in this segment, for those of you who listen regularly will remember, that I kind of go over the things that stood out to me in this conversation. Wendy has left the studio. She's on her way back to her firm's office. And what stood out in that conversation to me, and I'm curious what stood out to you as well, and one of the things that continued to leap forward to me is it seems like it's harder and harder to be an employer because of the rules and the regulations and the laws and the extraordinary number of laws that are being made. And I don't want to say behind the scenes. I don't think they're being hidden, but that the average employer is likely unaware of. These small rules that are made that the employer is suddenly beholden to, that they may have no idea existed out there. And I can't help but wonder from the employer's point of view if their attitude is something along the lines of, gosh, having so many employees is such a hassle. There's rules around it. It continues to become more expensive. And I think the best thing to do, the employer would say, is to figure out how to do better with fewer employees, which may give rise to the automations that we're seeing out there. I remember seeing years ago that there was a hamburger flipper that would flip burgers and eliminate the need for employees to be in a fast food restaurant because of this automated machine that automatically did it. And maybe it's commonplace today. Perhaps that should be an upcoming show. And if anybody knows anything about these manufacturers of such technologies that are eliminating the need for rudimentary labor, I'd love to be introduced to them. But the employer continues to look at ways, I would think, of having fewer and fewer employees because of what some would say continued overreach by the government into my workplace, making it harder to do what it is that I do, making it more expensive to do what it is that I do. I don't know. I can't help but feel a little bit sorry for the employers who have to jump through hoops and manage reams and reams of documents of laws and rules and hire HR managers and attorneys to figure out what they're doing. Feel a little bit sorry for them. Anyway, I appreciate Wendy for coming into the studio and talking about that. After the microphones are off, we talked about a number of different topics that she could come back with. And if you couldn't tell, she was well prepared and gave a very simple, thorough, cogent overview. Okay. I want to remind everybody, I think it's the week of July 13th that we're going to have the author Brandon Smith on the show. His book is called The Author versus Editor Dilemma. We will have an executive coach and one of the executive coach's clients all on the show at the same time to talk about the value of this book. If you want to participate, go get your hands on a copy of The Author versus the Editor Dilemma. Read it up as I've done and marked it up. You can see some of those markings in my social media posts as I'm trying to gather my thoughts around this conversation to interview the author with. So that'll bring us to a close. I'm always interested in who you'd like to hear interviewed on the show. You can reach out to me directly, cam@cammarston.com. Send me an email or go to the website, whatsworkingcam.com, where you can fill in a form there that will come directly to me on your feedback of the show and any guest ideas you have. You're listening to What's Working. That'll wrap us up. As you likely know, this show originates as a radio show broadcast across the state of Alabama, and it continues to grow in both radio listeners and market. After it's formatted for radio, we then turn it into this podcast. Please share it with those you think would find it interesting, and subscribe to the podcast on my YouTube page where you can leave messages and your thoughts and your comments, and I'll certainly get back in touch. Finally, if you're a fan of the show, please offer a review on Apple Podcasts or Spotify. You can find my book called What Works on Amazon.com. In it, I highlight the top 10 ideas from the first 200 episodes of the show. Mind you, they're not the top 10 best episodes, they're the top 10 best ideas. Many times the same ideas are brought up again and again by different guests, and we dig into those ideas in such a way that they'll be easily applicable for your business. Simply go to Amazon and enter my name, and you'll find What Works as well as my other books. Chapter titles include How to Find a Niche, Innovation, Building Teams, and so forth. To learn more about the workshops and seminars I offer, go to cammarston.com. There you can view clips of my work, view workshop titles, view my reviews, case studies, customer lists. It's all there. If you'd like a free copy of one of the chapters of my book, enter your email address at the bottom of the homepage at cammarston.com. And from that site, you can email me directly. I always love to hear from you. You'll also find me on social media. Find Cam Marston on all the social media platforms, and you may need to enter the numeral 1. There's one other Cam Marston out there, and that numeral 1 distinguishes me from him from time to time. So if you're unsure if it's me or not, enter that numeral 1 after my name, and it should do the trick. On a more personal and less professional side, I record weekly commentaries that air across Alabama on Alabama Public Radio twice each day on Fridays called Keeping It Real. They've won statewide and national awards. They're simple observations on the world as it goes on around me, and they're only a few minutes long. They're a passion. You can find them on the same podcast app you're using to listen to this. Finally, if you're interested in advertising on this podcast or the radio show, reach out. I've worked hard to cultivate a specific listener, and I can tell you all about them, and I have many different options for helping you reach them. Thanks again for listening. We'll have another episode available soon.